minutes, all right. Go ahead.
The child in this case is now 11 years old, and for the last 6 years of his life, his parents have disputed whether he should be allowed to fly as an unaccompanied minor. Although the magistrate permitted this in October 2021, after a full hearing, multiple witnesses testified, the trial court imposed an injunction in April of 2023, which extended the injunction through the child's 12th birthday, which happens to be in January of next year. Had the trial court applied the amendment retroactively, the injunction would have been lifted and would have brought an end to this protracted litigation. It would have also avoided an unnecessary hearing concerning a matter that was heard by the magistrate, the child flying issue, and it culminated with the minor child speaking with the judge in camera. At the time, the child was just 10 years old. This case presents an opportunity to honor the Tennessee legislature's intent and provide finality to a matter that has consumed significant judicial resources. Legislative intent. The General Assembly's amendment to TCA 37-107 clearly demonstrates its intent to streamline juvenile court proceedings, conserve judicial resources, and reduce the emotional and financial toll on children and their parents. This amendment, which replaced the de novo hearing process with a more efficient review, was designed to end redundant litigation and ensure finality in cases like this one. The amendment in question is procedural. Tennessee case law supports the retroactive application of procedural statutes unless the legislature intends, specifies otherwise, or if it impairs a vested right, or it would result in an injustice. The mothers...
In this case, the opposing party had already perfected its request for rehearing, correct?
Yes.
So why is that procedural?
The amendment is procedural.
The amendment is, but here the opposing party had taken all steps possible prior to the passage of the new law
It did.
and had perfected its appeal.
It did.
It requested the court to have the hearing. And the only thing anybody was waiting on was the court to have the hearing, right?
That's correct. However,
And so your position is the amended law does away with all that?
it does, Your Honor. Regardless of whether the the rehearing had been perfected, my brief cited other case law which had a similar situation where the party had already perfected its appeal, but still this court applied.
Which case are you referring to? Which case are you referring to?
I can't recall off the top of my head for right now.
Is it the case that the trial court was referring to, or the trial?
No, it's in my brief, Your Honor.
Okay.
And I can definitely give you that cite during my rebuttal.
Okay. Well, the case the trial court was referring to is
DeFreeze.
very distinguishable.
In that sense, Your Honor. But
In that sense, in that there was no perfected appeal
correct, Your Honor.
until after the law changed.
That's correct. That's
Is that a
correct.
vested right at that point?
No, it's not a vested right because case law is pretty clear as to determine what is a vested right. And here, the mother's argument is essentially that she had an expectation or a right to a particular remedy. And case law is clear that the General Assembly, it can change that remedy or procedure, and that litigants do not have a right to a particular remedy. And that's what the mother's argument hinges on. Now, the amendment, it only altered how a trial court reviews a magistrate's decision, but it doesn't deprive the mother of her rights. And also did not deny her her day in court. She had that in October 2021.
But here you're saying it does deprive her. I mean, if I understand your argument correctly, you're saying the trial court couldn't do what the trial court did.
That's correct.
So what's what's her right then?
Her right under this statute is that she still has the opportunity to have review of the magistrate's decision, which is appellate review. Notably, in
Appellate review here?
Yes, Your Honor.
Are you saying she could still do that?
Yes, Your Honor. But not in this matter because this is on.
Because that's final, if your argument's correct, isn't it? I mean, it's over.
No, it's not over because we do not have a final decision, Your Honor. The case is still
Well,
not
as
right
far
for
as her right to request a review, isn't it over?
a review before the trial court. Yes, she does not have that right. However, she does have a right for this court to review the magistrate's decision under the terms of the statute. Notably, in the DeFries case, the court upheld the retroactive application of a procedural statute that
Different
replaced.
situation totally.
I disagree respectfully, Your Honor. But what is notable is that in that case, the statute replaced de novo trials with direct appeals to the Court of Appeals.
But we don't have the same factual situation. You didn't have a situation where, in that case, the appellate in that case only requested an appeal after the law changed. Here, in this particular case, as I understand the facts, opposing party did everything it was supposed to, perfected its appeal long before the law changed. Then the law changed.
That's correct, Your Honor.
So why isn't that different?
Because the case law is pretty clear. It didn't make a distinction whether.
But you haven't given me any case law yet.
I have cited in the brief, and I can present that in my rebuttal, Your Honor.
Okay.
I'll provide that. The plain language of the statute is quite clear. The amendment's language is clear in the sense that the trial court cannot schedule a new hearing beyond what the statute permits. After briefing concluded, this court issued an opinion in Ferguson v. Trauber addressing a trial court's discretion under the amended statute to order a new hearing.
Did the statute say that it's applicable to all cases pending as of the date that it went into effect?
It doesn't say whether it's going to be applied retroactively or prospectively. It does say that it goes into effect once it becomes enacted. However, the same can be said in the DeFries case because in that matter, the statute wasn't clear either way. And I believe the takeaway from that is unless the legislature specifies that it shouldn't be applied retroactively and it doesn't impair a vested right or result in injustice, then retroactive application of the statute is the norm.
And you're saying that this appeal having been perfected in effect is not a vested right?
Correct. But in the Ferguson matter, I think it's notable because it addressed the application of this amendment. And in that case, the trial court had ordered the parties to brief whether this amended statute should apply to the mother's rehearing requests. However, the trial court in that matter decided to have a hearing de novo. I believe that case involved a name change. And the trial court, this court determined that that matter was waived because the father stated that it was a harmless error because he prevailed. And the takeaway from that is that this court, under the amended statute, suggested that the trial court having that hearing was appropriate. But that was in dicta, and it cannot change the statutory framework. For one, under subsection D1, a new hearing is only allowed if exceptions are filed and abuse of discretion is found. Subsection D2 limits new hearings to requests made within 10 days of the magistrate's order. That didn't happen in this case. Again, she doesn't have an opportunity to ask for a review before the trial court. However, she still has that opportunity for this court to review it. So again, the amendment's purpose is to streamline the process and limit unnecessary litigation by restricting the trial court's discretion to order a new hearing. So by upholding the statute's clear language and intent, this court can provide finality for a child who has faced prolonged uncertainty and relieve a system weighed down by repetitive litigation. This case should transcend procedural details. It should prioritize the child's well-being and ensures judicial finality. That concludes my time. Thank you.
Thank you.
Good morning, Justices. My name is Leanne Pafford Dobson, and together with my co-counsel, Zach Moore, we represent Amy Walters, the mother of the child in this case.
I assume you're making the argument.
I am.
Okay. You're not sharing time. That's my
I'm not
question.
going to share time with Mr. Moore. We decided it might be more cohesive if only one person spoke.
Okay.
Your Honor, first I'd like to point out that opposing counsel has raised a lot of issues in his brief and only touched on one here in the oral argument, but none of those are before the court. The only issue before you all is how do we interpret a new law that was enacted on April 25th, 2023? Prior to that law being enacted, the juvenile court rules were that anyone, for any reason, could file for a de novo hearing. My client did that. We perfected that. We did everything we were supposed to do under that law to make sure that we would have a rehearing in front of the judge. What happened next was it took 18 months before the new law was enacted. And during that 18 months, we had numerous motions, hearings. We weren't sitting around waiting. We were actively working this case, and we had a lot of disputes. We had discovery issues. We bifurcated the child support out of it. I mean, we were not just sitting around waiting for something to happen. We were actively working this case. And so then the law came along and said, okay, we're going to change this so that it is not an absolute right anymore. You have to ask for permission in order to have a rehearing. Well, that's a little different procedure, and we know that, but we had already done everything we were supposed to do under the prior law. I think that the two issues that the judge in juvenile court, and these are the only two he certified, was, does it require it to be applied retrospectively? And if it does, can the trial judge then expand the time period under which we would then file under the new rules? And quite frankly, Your Honor, I'm in the camp that I don't think that there's any reason why we should be here today. To me, it shows that the mother is losing a right if this is applied retrospectively. She had the right, she perfected it, she did it. I'm sorry that it's taken this long for us to get to trial, but if you've looked at everything, this is a very, very contentious case. The child is 11. What we have also argued is that, I think Your Honor has already pointed out, Judge Stafford, that the DeFreeze is not applicable in this case. It's very distinguishable. I don't think that's one that you would look at all. When you look at what we're actually arguing about is she requested her rehearing, she did it in the time specified, and if it were to be overturned now or say, oh, it's only retrospectively, then what about all the rulings that happened in the interim in these 18 months and the ones that have happened since then? This is an interlocutory appeal, so the case is still going on in many different facets. So the question is, where do we go from here? Is it fair to the mother, and I believe opposing counsel thinks it is, to deny her this right and make her not have any recourse whatsoever in this particular case in order to perfect what she felt like was an incorrect ruling originally and have the trial judge hear this case? I would also like to say that, Your Honor, I believe you should deny the father's request for attorney's fees for bringing this case before you. I think the legislature has made it very clear that, yes, it might be retrospectively, this new amendment might be retrospectively applied. However, we have to do what is fair and equitable for the people before the court. And I don't know how many other cases are also in the same boat with our court, but I'm sure we're not the only one. And I think that that's something that this court has to review. As far as the father, I'm sorry, I interrupted myself. As far as the father's request for attorney's fees, we ask that you deny that and grant the mother's request for attorney's fees, because this is one that I believe should have been here, should not have been here, because as I've repeatedly said, I believe there's a vested right that the mother will be denied if this is applied retrospectively. Do you have any questions from any of you?
See none. Thank you.
Thank you.
So to answer your question, Your Honor, regarding the differences between the Freeze case, I mentioned that there is a case that addressed a scenario where the trial court, which was affirmed by the Court of Appeals, applied retrospectively an amended statute that permitted intervening parties to participate in a de novo appeal to the circuit court when the statute was not in effect at the time the mother had perfected her appeal. So just because the
Do you have the case?
The case is in Ray Brooklyn. It's on page 26 of my brief.
Okay.
So the fact that it was perfected at the time, it doesn't matter, respectfully. Also, to counsel's argument that this issue regarding the application of the amended statute to the case is outside the issue certified by the trial court, I respectfully disagree, because the trial court sought guidance on the amendment's applicability to orders entered after rehearing requests, but before the amendment. The April 12th injunction fits this category. Also, it's our position that the trial court did not apply the statute retroactively to the case, consistent with the statutory framework, which allowed the amendment to conflict with the new procedural framework and resulted in a order that essentially modified the magistrate's ruling. And I just want to be clear, focus it on the injustice of not being able to have a second bite at the apple. That's what's being requested. It's not as though that the mother has raised totally new issues in the injunctive relief. It's the same issue, the child flying, Your Honor. And although initially the trial court stated that it had the jurisdictional authority to hear this because it was a post-dispositional issue, it wasn't. It was the same issue that the magistrate heard, the same fact pattern, which was the child's fear of flying. And I think notably, Your Honors, that the collateral attack doctrine should apply in this case, because what the mother sought was to defeat the effect of the magistrate's order almost 2 years later. Another fact I think the court should consider is that this wasn't her first attempt to do that. Her first time was in January of 2022, all right? And that injunction was based in part on the child's fear of flying. So what she wanted, specifically in that injunction, although it's a little bit different than what she asked for in April, was that she wanted the father to exercise his parenting time in Memphis, supervised, which would prevent the child from flying. And the basis for that was in part due to the child's abject fear of flying, and that's listed in our brief. So when you have a scenario where there is an amendment, which the General Assembly has the right to do, to change the procedures, to say that we're not going to have this anymore. No one gets a second bite at the apple. This is redundant litigation. So to avoid that, we have a collateral attack. That shouldn't be permitted. Otherwise, the amendment is pointless. Now, litigants can say that, oh, this is based on injunctive relief. And I think we can go to the trial court's latest, the last order that it issued amending the injunction. You would notice that the trial court seems to change its position from treating it as an injunction, which Rule 65 would control, to a modification of the magistrate's ruling using the modification statute. He stated that there was a material change of circumstances, but then it cites to subsection D2 of the amendment that the trial court had the discretion to order a new hearing within 10 days. The problem is more than 10 days had passed. So I think it's clear what happened. We had an injunction hearing that really was a de novo hearing. And under the statute, it's clear that that's not supposed to happen anymore. And the fact that this relief was perfected by the mother doesn't matter when you consider that she had her day in court. She testified. The brief lays out her testimony and the magistrate's response. And I think the court considered the child's fear of the age, because you would notice that in the order, it stated that the child is permitted to fly unaccompanied for direct flights. Then once he got older, he'll be able to fly unaccompanied on any connecting flights. Unless there are any more questions, Your Honor, that concludes my rebuttal.
See none. Thank you.
And if I may say one thing to Judge Golden. So my first oral argument, which was via Zoom, was before this same panel. And it's bittersweet that this is going to be my last oral argument before Judge Golden.
Thank you. Thank you, counsel. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We'll stand in recess to the call of the docket this afternoon.
All rise.